counter plan, and then the K.
T counter or T solvency counterpoint K. Okay.
You're next to Amy Rowland, yeah, sure. Right. Two is say one counter interpretation, top of graph is three people one or more that follow holdings in the decision. Two is counter standards, eight limits the best limits allows diversity of affirmative, allowing affirmative flexibility in this topic, otherwise there'd only be four asked, and B is ground. You get the same ground link cards talking about the entirety of the decision in a broad sense would still apply. And C is education, we can learn about the different aspects of the decision. And they destroy our ability to run Casey and Kieran-based affirmatives because they are bidirectional in their nature, meaning you would not be able to overturn all of the holdings in the argument and their interpretation. So I say it's arbitrary, no word in the resolution applies, the whole decision has to be reversed, and B is over limits, should only be absolute is bad for the both ground and destroys out limits. And they say that we would underlimit the topic, but they're talking about if we were only going off the decision, not the holding, which is our interpretation. And no vote on potential abuse, which is bills of concern and evaluate typicality, because we can win the round on typicality. Well, the competing interpretation leads to a race at the bottom, arbitrarily exceeding our actions by the interpretation, only our case topical.
Say they ran the counterplan too.
And they ran the counterplan, which
counterplan.
would then, it's the only way they'd be able to run a counterplan, meaning they can check all the abuse. So I'll see. They say states give protection now and possible Fed action, but it's a failure now. That's the first ACLU piece of evidence we're reading the status quo, and abuse is widespread. 75% of people are going to be victims of domestic abuse in their life, and each of the federal action is key because we'll be able to create a civil remedy. That's our gold farm evidence. They say the next two arguments they say that no one will use. The people are going to go, and it creates an important signal. That's our McKinnon evidence we read in the 1AC, and it's still been in the status quo. It's in our ACLU 2006 court, domestic violence, and the crowd state courts and state courts do nothing. At least from the courts to be responsive. No length civil rights remedies narrower than you might think. This is volume 2000. Except that I courts in Title III analysis of the implemented element of the violence of the because of gender. This foreclosure of active violence cannot be demonstrated by preponderance of evidence motivated by gender. A slippery slope argument. The majority debates motion on it. That Morrison proposes a greater filter overload. Next. Counterpoint. One is their solvency balance. It was fourth McKinnon 2000, but 2002 cards that the court needs to recharacterize commerce clause to signal past domestic Finland as much as other people. And two is prime two, but writing the 14th Amendment to do this domestic commerce clause justification solves their links to McKinnon in 2000. The Morrison court had found the limit desired to the rationale of the vow was equality purpose by the commerce clause history legislation, social equality. The vow didn't have the combining the commerce clause with the 14th Amendment rationale. Combining the two could have provided the basis of declaring limited construction consistent the precedents and the purposes of both the commerce clause enabling Congress to act the private acts of the economy and the enable and the confining the particular reason with Justice Douglas in the heart of Atlanta Motel, the dual basis and the commerce and security, the accommodation legislation upheld on the exertion of legislative powers, the customary to read granted powers, the law were recognized and based strongly. Justice Goldberg, the heart of Atlanta Motel, Title II Constitution, Commerce Clause, and 5 of the 14th Amendment, the combined rationale of the Commerce Clause would be on the same ground. There's no negative fiat derived from the word in the resolution, and it means the counterclaim goes away. And 3, no solvency, binary violence. It's in the McKinnon 2000 card. The man faces chase sexual inequality by the violence of magnitude, domestic violence in relation to commerce, and 4 topical counterplans voting issue for education and fairness. A's education, they allow 9 minutes 20 means it could be the same 9 minutes each, destroying some sort of debate. And B is grounding, encourages vague plan writing because you have to encompass the whole resolution and current strategy. You can see it's fairness, and there's no limited part of the resolution which they could not exclude or prepare the after before. And 5 is no solvency in turn. Federalism was no like standard of the 14th Amendment grounds. Their plan would oscillate federalism was bought in 2000. The 14th Amendment explicitly guarantees citizens no the laws of rich privileged communities, prohibitions against one of the states does not regulate private conduct, nor do the enforcement clause of the authority to full remedy vow would have to address state action. Title III, however, the private person, the violence, gender animus. Title III states created by a person or including a person under color of any statute use of the state commits a violence motivated by gender that it'll exactly the authority uses cleanly that's in statute. So individuals who therefore solely in private capacity, this contrasts the remedial authority state action given to the Congress of the 14th Amendment and no solvency. 14th Amendment only applies to slavery issues, doesn't have any the powers to regard civil rights as the Commerce Clause and no solvency. The civil rights for us and reversing Morrison from the Commerce Clause ground the only way to protect further civil rights legislation. This is low in 2000. A close link to the Morrison called the dilemma of civil rights legislation, civil rights by the name domain of the federal government, although it has historically prevented civil rights, Congress limited the enforcement to early civil rights since the time of the New Deal. Congress is more the logic Commerce Clause with the civil rights legislation, of course, and Morrison refunding action, any civil rights legislation restricting the private activity enabled in the past 50 years. And the Picks are bad. One, they're infinitely aggressive, can pick out of my front bed after has no reason to solve cases under risk of disdeclaration. B, it's
No,
time
don't
to...
do things bad.
Oh,
Go on.
counterclaim. Or the critique. At the top, they only have two links. The first is the Commerce Clause. I'm going to answer that. The second one is the victimhood, but that's still going to apply to the counterplan because they're still going to be able to create the sort of victims that the plan would also be able to do, meaning it's only a risk that it just links us as much as the counterplan. And Supreme Court application Commerce Clause jurisprudence uniquely shaped style of domestic violence statement when becoming invisible Johnson in 2003. A system where high-risk long judiciary field the tribes and the begin dominant members dichotomies. The judiciary plays a reinforcing corrective systems when the law quoting these views recognize the harmful behavior, discriminatory reverse is simply reinforcing power, sex discrimination, race discrimination, the world we live in, Congress recognizes discrimination, however the United States Supreme Court violence against the problem economic enough to warrant protection of the Congress's Commerce Clause powers when Congress violence women is family law, is criminal and inherently discriminatory standard review, gender discrimination, criticism of the male go unnoticed and legitimizes these women the protection of federal law. The important threatens to make women concerned and visible as powerful elite in setting and connecting gender violence to the Commerce Clause standard from women as commodities to women as producers from Resnick in 2001. The violence against women in particular should not be activities economic. It's painfully ironic when understood as all property. The Supreme Court has many times acknowledged that the women can be treated as commodities. Yet the women, the holders and producers of the property, the players of the market, the women, the economic terms is claimed to be a category order, and avoiding Commerce Clause language might be beneficial towards vitality in order to be achieving equality for women. This is from Resnick in 2001. The strategic reason why Bob related Commerce Clause understood by framing the violence against women in men commerce, descriptive the institution the current economy is framed by gendered allocation, subordinates women obtaining equal equality for women depends on gaining recognition as commercial actors. And the way they describe it in Crosslex is the simple discourse of the 1AC or the 1NC allows them to be able to gain some sort of solvency for their criticism. This is worse. This is a floating alternative, which is bad because we'll never be able to attack it, meaning we can't get permutations. We should be able to do all of our plan and then still use all of their discourse. And this destroys the affirmative's ground because we'll never be able to adequately debate it and leads to a massive time skews because then they can mute out of all of our offense by saying that their discourse is going to be able to solve for it. And we talk about men. Atypically, we stay away. We bring into the debate a discussion of these different gender identities. That's our second advantage in the 1AC policy. If this disproves why the link to victimization should still link to them, because we still work to break down these current things. And they're trying to object fiat away capitalism by having no alternative to be able to solve for it, as they specified in Crosslex as abusive in a voting issue. And if this turns into a voting pick and that means that capitalism solves the case, it's a voting issue. Ground where some picks literally have zero offense against the alternative and it's meeting targets so picking out representation, never know what they're really advocating. It's voter for fairness, education, and jurisdiction. And attempting to move away capitalism causes transition conflicts and an increased domination of sustainable exploitation. The Guru Road in 97. The global capitalism retreats the world dominating politics, politically feudal concentration of wealth and power, economic insecurity may lead to the rise of the demagogic national leaders, more predictable outcomes, chaos, shifting alignment, population, power struggles, ethnic conflicts inflated by demagogues, underdeveloped will be more dependent on major powers, access to technology, vulnerable, sophisticated form of control, subversion, or outright domination, and capitalism is inevitable. This is Olson and Leotard in 95. How do we resist capitalism? It's impossible. We have to resist because people are looking capitalist solution to their problems. Affordable to these people, fairness people without work, without money. They're waiting for capitalist investment to make things life supportable. There's no solution. Capitalism is the only solution. The only competition resides in pending against it. It's not to make people eat, work, sleep, and have a home and so on. In these conditions, real resistance can occur. And capitalism creates a system of surplus necessary for environmental protections. From Wilson in 97, capitalism makes it easier to deal with environmental problems. Some people consume more than they really need. It can compel internationalize without destroying an exchange. One must be able to induce the act. Democratic capitalism making all possible. Capitalism creates piracy of action. The creators of capitalism, an opportunity to move. No, I've seen the Soviet Union that provides privacy or environmental ethic. Capitalism produces prosperity, proximity to the minds of young people, and society becomes searching. And biodiversity loss about extinctions from Diner in 94. Biological diversity ecosystem characterized large number of species failing in narrow ecological niches by widespread extinctions. Humans have artificially simplified many ecosystems that cause a total ecosystem collapse or extinction. Each new extinction with the risk of disaster, like mechanically moving one by one, reducing airplane wind. We mankind. Yeah.
Okay. What is your argument after the permit?
I need elements.
Okay.
I guess I'll
Alright.
Never mind.
Yeah, that's fine. It's those, and then it's the first two cards after the index.
Yeah.
What is the argument that you make after the permutation on the counterpoint? Is there a theory argument there? It's not here.
Oh, yeah, it's no negative fiat.
No negative fiat. Why should we not get fiat?
This is derived from the word should in the resolution.
Okay, okay, that's fine. So we don't get any counterplans then, right? Is that your argument? No
Sure.
counterplans, no alternatives?
Sure.
Okay, so that means we defend the status quo then.
Yeah.
Okay.
That educates us as policymakers and stuff.
All right. That's great. Okay. What are the warrants in your Resnick evidence that you read on the,
It just talks about how by using the Commerce Clause, on the counterclaim,
or on the critique, I mean?
it talks about how using the Commerce Clause, it re-identifies women instead of as being like these,
Identifies them as having economic value.
it turns them
Right.
into producers instead of users, is basically, it actually gives them something.
So they're
impact
good
in
because they
society.
produce things and make money for people.
No, that's not what we're saying. Plus the permutation would combine
Well, I
the
don't-
14th
Well,
and
it's
the
not that they
Wait,
have
why
capacity
are
to be
women
producers.
being producers?
No, it's that they have the capacity to be producers. That
They have the
when
capacity,
a
so
woman
they
is
have the
abused,
capacity to make us money then.
no, to make themselves money, not us. I don't know where you're getting us
Not
from.
the bourgeoisie, just.
Okay. That's fine. Okay. What are the reasons? Let's see. What is the environment stuff at the bottom of the critique?
Just as capitalist nations treat the environment better.
Okay.
Like, look at this former Soviet Union, when they just had everything and everything was shared, so they just dumped waste with complete disregard
Okay.
everywhere and completely destroyed the
Can
environment.
I see the other counterpoint cards? I will take some of them.
Young, you read this whole Wilson card.
I read 4 cards.
Right, but this Wilson card is very, very long. You're gonna-
Is that the cat one? Or the environment one?
Yeah.
Yeah. I got it.
Society can comfort enough.
Okay.
Yeah, I know. It sucks.
Do you read an impact of federalism?
No.
No. Okay. So what does this Vaughn evidence?
That Vaughn evidence.
What's the worth?
It's just the one I believe it's talking about how a permutation could solve and how by working on the 14th Amendment alone could fail.
Okay.
I think it's actually about private contact, private actors, the Vaughn card on the counterpoint. I think it's
I'll
actually
read
about
that.
private actors and how private